Now, whether you would like the assessment because you want this tax return to die and prescription to start running, now that's a different discussion. But in terms of your obligations to SARS, you've done what you needed. Right. If you end up in the situation where, now if it's an estate where you can't finalize without the assessment, then obviously this is a big problem. If you are dealing with a scenario where they are wanting to look at saying, I want to be 100% crystal clear that I've dealt with all my tax debts or whatever the story is, then yes, also the lack of issuing the assessment is problematic. Is the only way the tax ombud? No. The tax ombud is one of the way to go, in the sense that you can also go, tax ombudsman is one, but remember you can only go to the tax ombudsman if you can show that you have escalated to the complaints management office. So your process always has to be CMO, then ombud. Okay. So, and the way I could submit the complaint to the CMO is lodge a complaint via e-filing. So CMO, tax ombudsman, branch manager, your RCB, those would be those are almost your default settings, if I can put it that way, in terms of looking for an answer. In this particular case, because you've submitted the return and are awaiting a decision on SARS, and SARS hasn't given you a decision, you could consider looking at either, in addition to my standard 4, you could look at a PAJA application, being a Provision for Administrative Justice Act, or I forget the exact name. Anyway, Procedural and Administrative Fairness, whatever else it is. Short version, the constitutional protection act that we have to go and say that, are we being treated in a constitutionally fair manner? That is the other option. Right. The other option would be that you go Rule 56, that you go and apply for a default judgment against SARS at a tax court to go and compel the decision to be made. Because by submitting a return, you're essentially going, SARS, ball is in your court, make a decision. And if they don't make the decision in the time frame in which it's been allocated to them, then the dispute resolution rules essentially go and allow us to go and say, hi, by the way, because you haven't said anything, we presume that our status is correct and our decision is correct. And that SARS then can't object to. So those really are going to be your options. I don't have a right or wrong in these because they each come with their own pros and cons, but that's essentially going to have to be your options. Okay. Directive issues. Right. Unfortunately, in this one, and in this one, I'd be very happy to take commentary, is in scenarios like this where the third-party information is incorrect, I've generally found that the best solution is always going to be tax practitioner appointment. And once you do the tax practitioner appointment, it's generally resolved. Okay, I've got a comment coming through from the chat box also saying a client's manual intervention was also not resolved after the 90 work dates. Complaint was submitted 21 work days later, still no assessment. Email sent to the Office of the Commissioner